This goes back to, I believe it was Clarence Darrow, or he's the one that's credited with this particular witticism. He said that the person who represents himself has a fool for a client. One of the problems with representing yourself is you're emotionally invested in your particular perspective, and getting an unbiased attorney to represent you is getting somebody who doesn't have that vested interest in you per se. The person will give you a good representation and be a zealous advocate for you, but the person can also look at the other side of whatever arguments there are and be able to anticipate those arguments and deal with them. Also, the fact is both bankruptcy and immigration are complex areas of law. These are not just, check a couple of boxes and that's it, especially if you end up with litigation. Certainly in bankruptcy, I've had calls from people who tell me, well, I filed my own bankruptcy and now I'm facing several adversary proceedings. And the problem with something like that is those adversary proceedings are very complicated. They're genuine, full-blown lawsuits, and they can cost a great deal of money. And so you're penny wise and pound foolish. You filed that bankruptcy on your own, saved on attorney's fees. And now next thing you know, you've got these adversary proceedings. And if you lose them, the debts don't get discharged in the bankruptcy. And if you fight them, well, fighting in a lawsuit is a complicated thing. Again, getting back to Clarence Darrow's witticism. So if you hire an attorney at that point, you may end up spending a great deal of money because adversary proceedings, as I said, are very complicated. So one of the things that comes up for people that decide not to consult a lawyer is the potential for expensive adversary proceedings. Another has to do with statutes of limitations. And I'll give you a simple example that I think is important, and that is in dealing with tax debts. Some kinds of tax debts are dischargeable in bankruptcy, it turns out. Income taxes that satisfy 3 requirements are dischargeable in bankruptcy. Each of these requirements is focused on a time period. So the first requirement is the tax return for the given tax year must have been due, with extensions if you got them, at least 3 years before the day you file the bankruptcy petition. The second is you must have actually filed a legitimate non-fraudulent tax return for that given tax year at least 2 years before you file the bankruptcy petition. And number 3, the tax you're seeking to discharge cannot have been assessed or have been assessable by the taxing authority, whether it's the IRS or the Franchise Tax Board, during the 240-day window immediately prior to the day you file the petition. Well, these are down to the day. If you're off by even 1 day, you lose. And so if you just decide to do things on your own, you may end up with tax debts surviving bankruptcy. And if you've gotten competent legal counsel who could have said, oh no, you need to wait, and it could be just waiting a couple of months. I've had this come up where a client comes in and we go through the analysis and I say, you got $15,000 worth of tax debt for this year. If you just wait a couple of months, we will be beyond that statute and you will be able to discharge the bankruptcy. That person instead had said, well, I'm going to do it on my own. I'm not paying some attorney to do this. Well, next thing you know, what happens? You end up emerging from bankruptcy with that $15,000 tax debt untouched by the bankruptcy. So there are lots of other things that can come up, but those are a couple that do come up fairly regularly. Yet another one that comes up, and this comes up with surprising regularity. It's based on something called a fraudulent transfer, although California law has now changed it to what's called an avoidable transfer. It's still the same concept. And the idea is that you have transferred something to somebody either with the intent to hinder, delay, or defraud that creditor, or you've transferred an asset without getting a reasonably equivalent value in exchange for the transfer. If you do that, that's called a fraudulent transfer. Now, outside of bankruptcy, a creditor can undo the transfer and seize the asset to the extent necessary to pay the antecedent debt. In bankruptcy, the trustee assigned to the case, and this comes up primarily in a Chapter 7, is empowered to avoid that transfer. And this is a somewhat unusual usage of the word avoid. It means to render null and void. Can avoid that transfer and seize the asset in toto, not just to satisfy particular antecedent debt. And the statute of limitations does play a big role in pre-bankruptcy planning. So if the trustee were to use the bankruptcy code's fraudulent transfer statute, then the trustee can go back, measured from your petition date, 2 years, and avoid any fraudulent transfers during that time. On the other hand, the bankruptcy code does permit the trustee to piggyback on non-bankruptcy fraudulent transfer statutes. So if the trustee uses the California Fraudulent Transfer Act, or the Avoidable Transfer Act, Uniform Avoidable Transfer Act, then the trustee can go back 4 years, measured from the day the trustee files the complaint to do the avoidance action. So that's 4 years, with additional time if the transfer couldn't have been readily discovered. And if on the day you file the petition you owe taxes, most particularly to the IRS, then the trustee can piggyback on the IRS's statute of limitations, which is 10 years. So I have had cases where client has owed income tax, and if we were to file, the trustee would be able to do a 10-year look-back period on the fraudulent transfer avoidance action. So we waited. And I remember one woman in particular, we had to wait something like 6 months, just 6 months, to get past the IRS, or for her to pay off the tax debt before we filed. Then it was stuck within the 4-year statute of limitations, and the transfer had been done 5 years earlier. But if she had filed with those tax debts still intact, then the trustee would have been able to avoid that fraudulent transfer and seize the asset, and it was a house. So that would be a very, very big deal. So those are some common things that come up, at least in my practice, where people have hired me, and if they hadn't hired me, bad things would have happened. Fraudulent transfers would have been avoided. They might have emerged from bankruptcy with tax debt that could have been discharged. So generally being penny wise and pound foolish is not a good idea. I mean, I read about some guy that did his own appendectomy. I think he probably needed some very severe, serious psychiatric care, but he did his own appendectomy and filmed it. Well, I have not had an appendectomy, but if I needed one, I would definitely go with a competent surgeon and not do it on myself. And in similar fashion, as an attorney, if someone sued me or I needed legal counsel, I would hire somebody to do it, because I know that in my mind, I'll be so focused on my position that I won't be able to see what the other side's position is and be able to anticipate arguments from the other side. So yeah, you can represent yourself. Absolutely. That is something that is afforded to you by law, but sometimes that's much, much more expensive than hiring a competent attorney.